It's Richard Burgess here from the legal team. Some of you may know that I am a solicitor in the private client legal team, and here I'm going to talk a little bit about documenting gifts to beneficiaries and how you can go about doing that so that you can prove to HMRC that a gift has been adequately transferred. Main benefit, of course, is that there are no protracted discussions with HMRC further down the line, and avoiding worst case scenario of HMRC finding that an asset remains in somebody's estate and therefore more inheritance tax to be payable. There's the other advantage, of course, which is to speed up the administration of a probate, so the executors can get the job done and transfer the assets to the beneficiaries as quickly as possible. So lifetime gifts. So if your client is looking to transfer assets to a beneficiary, the information that the executors will need to provide in the inheritance tax in due course is the stuff that's listed here on the screen. So some of these are obviously fairly straightforward. The date of the gift, very important for whether or not 7 years have elapsed in order for the asset to fall outside of the estate. Full name of the donee, relationship between donor and donee, obviously that last one principally to ascertain whether or not a spouse exemption or a charity exemption applies. The last 2 points, a detailed description of the gift, such as the class of shares or the tenure of property. Now, it's best to make that as detailed as possible, particularly when it comes to shares. If you can just make a note of the precise class of shares and how many shares are being transferred, make a note of that at the date of the gift. And similarly, it should be fairly easy to work out later on the tenure of a property, so whether it's leasehold or freehold, in the event there's any ambiguity further down the line. Also, that final point there about whether business relief or agricultural property relief might apply. If you are going to claim those things, obviously you've got to satisfy yourself that all the requirements have been met, and obviously it's the information at the date of gift that's applicable here. So to save the executors time later on and to make sure there's no queries from HMRC, it's probably a good idea to write down how those criteria are met, possibly in a deed of gift, or at least have something on the file note so that the executors can be comfortable that there would be no tax to pay on a gift that did actually was in fact eligible rather for a relief. So formalities, how can you show that a gift has been made? Well, in the case of land, the starting point is the title register of the land registry. Now that, of course, is on the basis that the land is registered with the land registry, and that's not always the case. There is still some unregistered land out there, but in the absence of any contrary evidence, the title holder at the land registry will have the legal title, and therefore it can show that a gift has been adequately made to the donee. Shares, stock transfer form usually will suffice, so make sure you retain a copy of that and your client retains a copy of that form. Other gifts, obviously there's no formalities really needed if you're going to give cash or a personal possession to a beneficiary. So if you're going to give a painting or a musical instrument or something valuable that you don't need to receive in order for the legal title to those assets to transfer, then a deed of gift is absolutely recommended at that stage to be signed by both the donor and the donee, so there is clear evidence at the time that the transfer is made of what exactly the assets were that are being transferred and when the assets were transferred. So like I say, anything like jewellery, a car, actually a car there's a logbook, but anything where there's no legal formality, certainly worth getting a deed of gift in place. Now, attorneys are able to make gifts on behalf of the donor of the lasting power of attorney. Always worth taking advice before taking that step, because the scope of an attorney to make gifts is quite limited. It's gifts that the donor would ordinarily be expected to make. So typically this means birthday presents, Christmas presents, etc. If an attorney is suggesting that an asset which is particularly valuable, or the gifting of it is out of the ordinary, what they're suggesting is, of course, they're depriving the donor themselves of that asset. So typically an application to court has to be made. Certainly not unheard of. Those applications obviously can take a bit of time, do cost money, but the attorney might think it's in the donor's best interest for that gift to be made, and so that application has been known to be made, and I'm sure will be made in future. But again, document things as best as possible with a deed of gift, and in that deed of gift, just set out the power that the attorney has to make the gift, including the date of the registration of the LPA, if at all possible. So gifts with reservations of benefit. So obviously these are to be avoided if at all possible, purely because obviously worst case scenario, you're depriving the client of use of an asset, but HMRC is not convinced that it's fully left their estate, and so then will tax the value of that asset on their estate. So worst of all possible worlds there. So the HMRC's position, and it's set out in the inheritance tax return, is that the donee must receive full possession of the gift. Now, if there's any doubt as to whether or not the gift is in the donee's full possession, again, a deed might be the way to go there, just to have the donee confirm that yes, they have full use and access to the gift, and that the donor has no claim on it. Now, where a client continues to reside in a property and they've given some or all of the interest in that property to somebody else, obviously in order for a gift with reservation of benefit to not apply, then a full market rent must be paid by the donor to the donee. And that market rent must be reevaluated on a regular basis. So best practice here would be for the donor to say, I'm continuing to live in this property, I've given the property away, and in order to do so, I know I need to pay rent. I've received probably at least 2 market valuations as to what that rent might be, then some evidence that that rent is being paid and is continually reviewed. That will save an awful lot of time further on down the line in any future discussions with HMRC as to whether or not the gifts with reservation of benefit rules apply. Now, we have had a couple of cases where a donor has purported to give a valuable item, such as books or a painting, to somebody else, but continue to hold on to those assets in their own home. So, for example, if a painting is still hanging up in your home when you said, well, actually, I've given it to my son or daughter, HMRC will say, no, well, you've obviously not given it away. So any kind of evidence that you can produce which shows that actually you have transferred it, so a photo showing the book or painting or whatever it might be in the donee's possession, such as hanging on their wall, would be useful evidence to produce to HMRC. Gifts from surplus income. So it's obviously a tax relief where you don't need to survive the 7 years in order for the gifts of your surplus income to fall outside of your estate if you're given to a chargeable beneficiary. Now, obviously, it could be potentially quite a lucrative relief, this one. So the proportionate level of detail is required by HMRC. And I've listed in the slide here the things that are set out, or some of the detail that is set out in the IHT 403 in the inheritance tax return, which is required. So income such as salary income, pension income, interest, rental, all these details, obviously a lot of them will be in a tax return, but if the client isn't required to complete a tax return, then having these details to hand separately would be very valuable information to have. Also, all sorts of outgoings, so utility bills, holidays, travel expenses. There's quite a lot of detail here that's required over quite a lot of period of time. I just flag up with your client at an early stage that, yes, it's a potentially lucrative relief, but make detailed notes on a variety of sources of income and liabilities at an early stage, and then continuing, so that that information is readily to hand for the executors, so there's no protracted conversation with HMRC as to whether or not the donor was required to survive the 7 years. So a final note on wills. Where a testator has made gifts to a chargeable beneficiary, so typically their child, during their lifetime, and they have more than one child, and they think, well, really, it's not fair to benefit one child more than the other or the others. So we can include in the will a clause which says that there are beneficiaries of my residuary estate. For example, 3 children, I've given X to first child, Y to second child, and nothing to the third child. A clause in their will can say, ultimately, all 3 children will get exactly the same amounts. You're taking into account the lifetime gifts. This we found is very useful, and clients find it very helpful, because it means that their will remains fit for purpose, not only for gifts they had previously made, but gifts they are minded to make in their lifetimes. And on that note, that is my extension number and email address. So any questions relating to documenting gifts to help executors in due course, or the contents of somebody's wills, do please get in touch. Thank you.